Elham is the director of Lawyers for Justice in Libya, and of course also very distinguished SOAS alumni, so it's a homecoming for Elham, and you're obviously always more than welcome to join us, especially for this amazing event again. And Elham and Lawyers for Justice in Libya have been the driving force, so it is very appropriate for Elham to introduce you properly to the event and talk you through the program for tonight. Elham, please.
It's a success when I get up the stairs, so that's good. Thank you so much, Lutz, and thank you to the Center for Human Rights Law at SOAS. Lawyers for Justice in Libya was born in SOAS, actually. I remember very, very clearly being in the Human Rights Clinic with Professor Welchman coming in and saying, first we had the Egyptian revolution, then we had the Tunisian, and it felt like we skipped Libya. And every day we'd come into the clinic, we're like, what's going to happen next? And then our turn came. And I came in, and I remember very distinctly, because it's Professor Lin, and if you know her, you know that she never tells you can't do something. And so I said, I feel like I should do something. And she's like, yes, do something. And so it was almost like we established this, I don't want to say war room, because she would also be very upset with me for using military language to talk about human rights. But she told us to establish a room, and it was physically a room where there was me, her, Professor Scobie, Lutz, all of Professor Uta now as well, trying to figure out what we can do. And it started off with a very ambitious but simple exercise of trying to translate the laws of armed conflict to those who had taken up arms on the front line. And we came up with this handbook that we somehow convinced the Libyan authorities at the time to disseminate. And they did it through mobile phones. And it was this kind of really bizarre, super surreal experience. But it was a real education in how to make law real. And I think that's what SOAS did for me, and I know that's what SOAS does for students. It takes law out of the books and into practice in a unique way. And so I'm very, very grateful to call this my alma mater, but I'm also very grateful to be invited back for us to host this every year, right? Every year. Over a decade on from that, LFJL has grown, but we hope that we still kept our enthusiasm, our optimism, and our commitment to Libya, and the belief that we are building a country that is based on the rule of law and protects human rights of all people. In the current environment, our work and that of other Libyan civil society is under severe threat. The crackdown on civil society at the moment is unparalleled in the last 11 years. And this challenge is a real one. I think sometimes we describe this and it becomes words, but daily we hear of the phenomenal crackdown on those trying to do this work. We at LFJL are prioritizing this work, and we're very proud of our work in helping to do some small steps towards building a more resilient civil society. And I'll just highlight one thing, if I may, with this audience, is to say that we were really proud this year of launching our CSO Academy, which is really about building the infrastructure of civil society. When we think about the work we do and who supports our work, most of the time what's supported is the project, but not the people or not the organization. And so what the CSO Academy does is try to address some of that deficit by helping institutions really understand the really boring parts that make an organization work, like what your mission statement is, or how you set up your structure, or what programs you have, or how you fund, or how you do your financial reporting, all those things that make you viable and make you sustainable, but no one wants to teach you. And so that's what the CSO Academy does, and it's probably the thing I'm personally most proud of. And it's been a privilege to meet just phenomenal people through that, and we're grateful for that. But I won't go on about our work. If you would like to know more, you'll see some very friendly-looking faces wearing little blue badges. They're all LFJL. And so if you want to grab them at any point to chat about our work or to find out more, please do. And how you can support us, please do. But today we're looking at a question that really does impact our work, but more so, it really impacts the transition that Libya is on. The road to peace, which is what we're referencing in this title, is the road to stability, and it's of course never smooth. But in the last 11 years, Libya's future has become more and more in jeopardy because of armed groups, because of the stalemate in the international community, because of the widespread corruption, and because of the overwhelming culture of impunity that's thrived and has been promoted by all actors. To help us unpack this, we're really thrilled to welcome Ambassador Beth Van Schaack, who I had the pleasure of spending the afternoon with. And I really hope that we'll have an opportunity to really get into the nitty-gritty and really to think about what it means when we talk about criminal justice and how it can help pave peace. Beth, if I can call you that, Ambassador Van Schaack, that's so chunky, is one of the world's foremost experts on international criminal law and human rights. Ambassador Van Schaack has extensive experience in teaching and researching and practicing criminal law, human rights, and conflict resolution. Most recently as director of Stanford's Human Rights and Conflict Resolution Center, or Clinic. Today, she addresses us in her relatively new capacity as the Ambassador at Large for Global Criminal Justice for the United States. Without further ado, I'll invite you up, and I'll encourage you all to perk up your ears. Thank you so much.
Well, it's a real honor to be here. Thank you so much for convening us. It's a fantastic organization, and I'm really honored to be able to give this annual lecture. This is an important topic, and this is a great venue in order to bring this topic. I'm quite familiar with the work of SOAS, and I've met many students over the years, and I'm always incredibly impressed with their ability to straddle practice and theory. And I think you're exactly right that this institution really fosters that and creates individuals who will be able to think hard and analytically about things, but also put things into practice. And so it's an honor to be here. I'm really thrilled, and I really look forward to the conversation. So I am indeed the 6th Ambassador at Large for Global Criminal Justice. I'm thrilled that my former boss, number 4, is here as well, Stephen Rapp. I was his deputy under Secretaries Clinton and Kerry, and so I've tried to carry forward so much of the energy and passion and respect for victims and the dignity of all of humankind forward as I've occupied this role now within the U.S. State Department. I was sworn in on March 17th, just after Russia launched, or I should say relaunched, its war of aggression against Ukraine, and so this would have been an enormous job, even without Ukraine, and now it often feels crushing, given the enormous needs for justice around the world, not just in Ukraine, but elsewhere. And so much of the world's eyes are on Ukraine, and yet we know that that's often taking eyes away from other situations that have been demanding justice for many, many years, including within Libya. So it's a time of extraordinary challenges, but also I want to say opportunities, and that's really what I want to focus on today, is do a little bit of a tour du monde of the system of international justice, because it's becoming increasingly interlinked, disaggregated, creative. I wrote a PhD on imagining justice for Syria, and the subtitle was "Water Always Finds Its Way." And in this way, I think justice always finds its way. With any little impediment that you put, it will find cracks, it will find a way downhill, and it will eventually move forward. And I think that's what we're seeing even in places where impunity feels really intractable. So my job, because it's somewhat of a unique position in the world, I don't have a lot of counterparts around the globe. The mission of my office is to essentially advise the secretary, but also other interagency colleagues around the U.S. government, and also to work with Congress on the development and execution of policies to prevent atrocities, but also to respond to them after the fact, and generally through mechanisms of justice and accountability. I engage in international diplomacy on the multilateral stage. I try and build partnerships with like-minded states. I often have to reach out to states that are less like-minded than one would like them to be. And I also deploy a small programming budget, which is new from my time at GCJ, the Office of Global Criminal Justice, under Ambassador Rapp. And so now we're able to work directly with civil society organizations that are pushing the justice mandate forward. And it lets us do this in a very strategic and structural way. So it's a great evolution for the office. Advancing accountability for war crimes, genocide, and crimes against humanity are really the guiding principles that we work with. And we do believe that ensuring accountability is essential for peace, because we have seen over the years the way in which grievances fester if they're not addressed through some sort of a formal justice process. And that inevitably consigns societies to have violence repeat itself if people don't feel as if what they have experienced has been acknowledged and some measure of justice, maybe broadly defined, but some measure of justice is not achieved. And we also, in all of our work as policymakers and as diplomats, try and work directly with survivor communities in order to understand their lived experience and to ensure that whatever policies we're implementing within either the US government or that we're promoting on a multilateral stage really reflects their priorities, their expectations, and their preferences. So in this regard, the mandate of the office is not just about criminal justice, although that is in the title of our office, but we do focus on the whole range of transitional justice mechanisms, thinking about truth-telling, thinking about retributive justice, but also more restorative or reparative justice, thinking about lustration or vetting regimes, and thinking about measures to ensure non-repetition, so institutional reform measures that will encourage institutions to operate more fairly, more openly, more transparency, and with greater accountability. Keeping this in mind, what I thought I would do tonight is talk a little bit about what the Biden-Harris administration is doing in this space, not necessarily to be bragging about what we're doing because it's never going to be enough, but to offer a set of examples of what states can do, either individually or when they work together with other partners and allies, to promote justice wherever it's needed and to look for those creative ways to take advantage of openings and spaces and opportunities that might occur, even if they're unexpected, but to be able to move quickly in order to capture a moment to advance imperatives of justice on behalf of survivors and victims. And although I'll put some emphasis on Ukraine, I'll also at the end turn to the situation in Libya. And I want to be honest with you, and when I say that our office has not focused much on Libya, in part because there haven't been many viable justice pathways for us to engage with. And this lecture has actually encouraged me to think about how to change that and to try and implement more of this attention on this situation into our work. And so again, this is partly why I'm really looking forward to this conversation, because I want to hear from you as to what the United States can be doing, but also using our convening power or our voice in multilateral fora in order to try and amplify some of the justice efforts that I know are happening on the ground in civil society, in courts around the world, in a global epistemic community that's focused on pushing these issues forward wherever they're able to do. And so this will be a bit of a tour du monde, as I mentioned, of the kinds of institutions we're seeing, the kinds of efforts we're seeing, with a little bit of an emphasis on what I'm trying to accomplish in this role with my office. And as an overarching observation, what I can say is that the globe is actually increasingly united around an understanding of the imperative of justice in respect to conflict situations or situations in which societies are emerging from periods of great repression or of authoritarianism. This newfound solidarity, I think, has been very much inspired by the situation in Ukraine following Russia's reinvasion, but it's not unique there. And I think it's opening up a space for conversations elsewhere that might have been stifled or quieted over the years after a period of time of impunity or feelings in which progress was not being made. Efforts are becoming revitalized, I think, and the situation in Ukraine in many respects has inspired that. And we've also seen a lot of new creative thinking about institutional responses and institutional design, and I think these new models could be applied elsewhere. The institutional framework for international criminal law generally and accountability is also increasingly decentralized and multipolar. And this is allowing new ideas to flourish and institutions to be better contextualized and more bespoke to reflect the cultural context in which they're operating. There is no one-size-fit-all model. The ad hoc tribunals of the 1990s have not been replicated for reasons that everyone in this room understands, but instead what we've seen is an evolution of these institutions, the development of more hybrid tribunals that bring together elements of the national domestic system, capturing the legitimacy that brings, paired, though, with international investment and other forms of involvement, including personnel, international law, perhaps being stood up outside of the country if the security conditions don't allow. And so some of these hybrid institutions and these hybrid models can bring the best of both worlds. We're also seeing, I think, a deepening state practice around extraterritorial jurisdiction, universal jurisdiction. I know there are some fantastic practitioners here in the audience of this craft. The idea of structural investigations, where national authorities open an investigation into an enormous crime base of international crimes, be it war crimes, crimes against humanity, or even potentially genocide, without any particular target necessarily in mind, but with the goal of understanding how violence worked, what the vectors of violence are, who the key perpetrators are, how the system operates. And then be ready to act when there are targets of opportunity that come within the jurisdictional reach of those particular authorities. These structural investigations are being opened all across Europe, the countries of which have established these war crimes units of specialized prosecutors and investigators who really understand the elements of international crimes. They're increasingly interoperable and interlinked, sharing information through, for example, the Eurojust Genocide Network, but also joint investigative teams that are being formed to focus on particular crime scenes, particular incidents, particular societies where international crimes are happening. And norm entrepreneurs, many of whom are in this room, are also thinking really creatively about how to take advantage of this increasingly decentralized system in order to promote justice wherever there might be an opening to do so, and not simply assuming that there's the International Criminal Court or nothing, or there's domestic courts in the territorial state or nothing, but thinking about where jurisdiction can be stretched or established in courts around the world. The Biden-Harris administration has really put an emphasis and a premium on multilateralism, and this, of course, is a stark departure from the previous administration, which turned its back on many multilateral fora and instead proceeded alone in many of these endeavors. The Biden administration has been trying to invest in these institutions to ensure that they are capacitated appropriately, to ensure that they have good staff and leadership, and then trying to work through and with them in order to address global crises, whether it be climate change or otherwise. And the approach to justice is very similar. So prior to my appointment, the Biden-Harris administration had launched essentially a reset of the relationship with the International Criminal Court. And you will recall that under the Trump administration, the chief prosecutor and one of her aides had been sanctioned for the opening and continuing the investigation into the Afghanistan situation. And the relationship had really reached a new nadir, even though over the years it has been, at various stages of constructive engagement versus withdrawal, depending on administration and other global macro issues happening out there in the world. And so the Biden administration, before I was there, and I emphasize that because it wasn't just about bringing someone like me into the administration. This was a whole of government approach to say the policies and practices of the past were not only misguided and did not achieve what was attempted to be achieved, but they were actually wrong and should never have been pursued. And so that approach was rejected, and this reset was launched. And so when I entered the job on March 17th, I had a very clear mandate to continue to build a constructive relationship with the International Criminal Court and to look for ways to advance its important mandate, but not looking at it as the exclusive institution doing this, but as part of an embedded, as Ambassador Rapp will say, ecosystem of international justice. One element of this relationship is information sharing and supporting the work of the Office of the Prosecutor. And so we have looked for ways in order to do this using the unique sources of information that we have. We've welcomed the opening of different proceedings, including, for example, in Darfur, where we now have finally the first case moving forward. And you might recall that during the administration of the George W. Bush era, the Secretary of State Colin Powell launched a really important and at the time unique initiative to do an empirical population-based study of Darfuris who had left Darfur as, in most cases, refugees, but were able to be found, interviewed, using statistically rigorous methods in order to reach the conclusion that genocide was actually happening in Darfur, and that undergirded President Bush's determination, which then helped to lay the groundwork for the administration allowing the referral to the ICC to go forward. And that marked a real pivot point of the relationship, which had started out quite hostile in the early days of the Bush administration, but really had evolved by the end of the second term of that administration to recognize that the court played an important role, particularly in a situation like Darfur, where there was no options of domestic justice at all, very little opportunities for any form of universal jurisdiction. So really the ICC was going to be the only game in town, and it needed to be invested in and strengthened so that it could operate the way the court was designed to operate. The U.S. has also been involved, and we've tried to provide steady diplomatic support for the court, whether it be in multilateral fora like the Security Council or the General Assembly or elsewhere, or in our bilateral relationships. So one of my first trips was to The Hague, where I met with all the different organs of the court to get an assessment of where things stood in their work, look for ways in which the United States could be supportive, where were the needs, how might our sort of unique position in the world be able to be responsive to those needs. And then we work on a bilateral basis. So, for example, in our relations with the Sudanese authorities, even as they're in the midst of a political crisis, trying to encourage them to respect and adhere to their cooperation obligations in the Security Council Referral Resolution 1593, to commit to and to implement their promises and obligations from the Juba peace agreements, and to allow the ICC to operate in an unhindered and unfettered fashion, including opening potentially field offices, unimpeded access to key witnesses, a field presence, teams to travel unheeded. It's not perfect, but that is part of our consistent messaging with the government. I was also able to deliver an intervention at the Organization of American States, which had convened a special working meeting on strengthening cooperation with the International Criminal Court. Many states of the region are court members. They're very active in the assemblies of states parties. And in that forum, I was able to express our support for the work and also for the opening of the situation in Venezuela, but also to commend the region for being such innovators in so many of the mechanisms now that we take for granted as part of the transitional justice toolkit. They had their origins and basis in the post-conflict, post-authoritarian periods within Latin America, and those have now proliferated, and we've seen them across the globe, and communities all over the world are picking and choosing among the sort of menu of options and tailoring them to their own particular situations. Next week, in fact, we'll be in The Hague, and I will be able to deliver the first intervention by the U.S. by an ambassador at large in, believe it or not, 6 years, because we've had a series of acting individuals and then non-participation by the United States, and then, of course, a global pandemic, which was in the middle there somewhere. So it will be great to be able to be there in person and to be able to articulate some of these commitments to that particular audience. The other thing we've tried to do is visit some of the ICC situation countries to see the way in which the work of the court is supporting or working in parallel with domestic efforts to promote accountability. So the first trip I made in Africa was to the Central African Republic, whereas there's this really interesting experiment in hybrid justice happening, where there are justice institutions operating at 3 levels. National courts are operating, again, not perfectly, but there are cases moving forward. There's the Special Criminal Court, which is a hybrid model with a lot of international investment. And then there's the International Criminal Court sitting in The Hague, but looking at the same particular crime bases and working in greater cooperation with the domestic counterparts in order to think about what is a logical division of labor when we're thinking about how do we allocate justice, how do we identify responsible individuals, how do we pick which incidents to focus on. And I was really pleased to see the degree to which that cooperation was happening through the field presence of the ICC within the Central African Republic. I was also incredibly impressed by the dedication of the national and international personnel who are working in that institution with very little in the way of resources. It's happening. They've issued their first judgment. I'm really pleased that the U.S. Congress has had an earmark of $3 million for the Special Criminal Court that has gone towards witness protection issues, towards the creation of an effective and professional sort of file management, other sorts of technical assistance, forensics, et cetera. We've also started to contemplate potentially an additional Security Council referral In his statement marking the 5-year anniversary of the 2017 genocide in Myanmar, the Secretary Blinken announced that the United States would be interested in exploring the degree to which the Security Council, in exercising its peace and security mandate, could potentially refer the situation within Myanmar to the International Criminal Court. It clearly meets the gravity threshold and also the concerns about complementarity, since there are no credible domestic prosecutions or any sorts of investigations, or for that matter, any transitional justice measures at all happening. In effect, rather, violations are continuing to happen, not just against Rohingya, but also now as part of the crackdown on all communities that are protesting the military coup that happened recently. This followed upon the heels of a really moving speech that Secretary Blinken gave at the U.S. Holocaust Museum, announcing the U.S. determination, again based upon an empirical study by civil society actors, that a genocide was occurring within Rakhine State. In this regard, we are continuing to support the international independent mechanism that's devoted to Myanmar. This is a new model of investigative mechanism created by, in this case, the Human Rights Council. We've given an initial $1 million in order to support the work of open source investigations by that entity, because they, of course, don't have access to the territory within Myanmar. And then a second $1 million grant I was able to announce at the recent meeting of the General Assembly that will be focused on witness protection. Not just the protection of vulnerable percipient survivor witnesses, but also thinking about how we can better protect those insider witnesses who might be willing to meet with and speak to investigators and prosecutors to explain how the system is organized, how the chain of command works, who's the most responsible, what orders were given, what individuals turned the other way while violations happened. All of those things that are so necessary to bring a credible and an effective prosecution going forward. We're also revitalizing the War Crimes Rewards Program that my office administers. This is a program that offers rewards for information leading to the capture, transfer, or conviction of individuals who stand accused of war crimes, crimes against humanity, or genocide. It's been extremely effective in a whole range of situation countries. The law was amended under Ambassador Rapp's tenure in the office to allow for rewards to be paid for ICC fugitives, and so we have a number of outstanding rewards, one of which is focused on Joseph Kony, the sort of messianic leader of the Lord's Resistance Army, who has managed to elude capture all of these years. We've tried to revitalize that reward, and it's generating a whole bunch of really interesting information that now can be potentially acted upon in order to determine his whereabouts and ideally, hopefully, bring him into justice. And in this regard, we're looking to make potentially additional designations in the future. So this is a little bit of a snapshot of the way in which even a non-party state like the United States can support the work of the International Criminal Court, knowing that ratification is probably a bridge too far for the United States, at least for now. I just want to call out a number of other institutions that are out there. We have, of course, the residual mechanism that's doing the closing work of the Yugoslavia and Rwanda tribunals. Really important work still to be done there with some of the few last cases and appeals. The U.S. continues to be a supporter of the Kosovo Specialist Chambers, which were established to investigate crimes committed within the Kosovo situation that fell outside of the jurisdiction of the Yugoslavia Tribunal. We contributed quite a bit of money to the international component of the extraordinary chambers in the courts of Cambodia. They've recently shut down after not really completing the full mandate in a somewhat controversial outcome, but nonetheless, the work of the ECCC created a space and a platform for dialogue within Cambodia that would never have happened had that institution not existed. We're also supporting other international investigative mechanisms like the IIIM, which is focused on the situation within Syria. And we recently have announced our support for a new initiative to focus on the detained and the disappeared. It's not, strictly speaking, or really at all, an accountability mechanism, but rather very much inspired by the humanitarian needs of the families of those who are in detention or who have been disappeared. And the idea is to gather together all the information that we have on the last known whereabouts of these individuals, and the hope that the Assad regime will recognize the humanitarian imperative of providing some information if individuals remain within custody so that they know that their loved ones are still alive, and to give, if not definitive information as to their ultimate fate. It's not clear that the Assad regime will be willing or interested to participate in this, but there is information held in multiple different sources, and so the idea would be to bring this together in the service of the families. We're also quite supportive of UNITAD, which is focused on the crimes of Daesh, ISIL in Iraq, and they're doing incredibly innovative work, even though Iraq does not have a domestic crimes against humanity or other international crime statute to be able to bring those cases domestically. They're doing a lot of work around forensics, working with victims' communities, and also making information available to other courts that may be able to proceed with cases. We have helped to stand up, as Ambassador Rapp called tonight, a mini mechanism, which I'd never heard that, but a Sri Lankan accountability project that's focused on the implementation of the strong resolutions that came out of the Human Rights Council, which during a previous regime, Sri Lanka acknowledged and agreed to implement. They've moved off of that pledge in subsequent regimes, but the hope is to bring them back into a pathway where they would be willing to consider using various transitional justice mechanisms to address the crimes of the civil war with the liberation tigers of Tamil Elam. So Ukraine is taking up a big piece of my work. I was, of course, confirmed just after Russia's invasion, and so I inherited a pre-existing project that was working with the Office of the Prosecutor General to support, at that time, her work, bringing war crimes cases from Crimea, the Donbass, and eastern Ukraine. And the idea was to send experts, veterans essentially, from the world's war crimes tribunals in order to work side by side with their counterparts in the Office of the Prosecutor General to help prioritize cases, to help identify evidence that would be probative and could be authenticated. Individuals who had worked on, for example, the siege of Sarajevo would be working side by side with individuals who were about to prosecute the siege of Mariupol. And so, of course, after February 24th, we've had to scale this project considerably in order to address the fact that Ukraine will now become one of the biggest crime bases in human history, and maybe one of the best documented crime bases in human history, given the high degree of penetration of sort of cell phone use and satellite imagery, et cetera. And so we've been able to give $10 million to Georgetown University, which is the key implementing partner, in order to bring together a roster of experts and to send and deploy them into Ukraine to work side by side in two different projects. One, a prosecution support unit sitting in Kyiv to think about the big ticket sort of strategic questions, and then mobile justice teams that will be working out in the field and can be deployed immediately after a particular incident happens in order to lock down a crime scene, gather the evidence necessary, do the kind of collection of evidence that's going to be necessary to be admissible in a court of law, either in Ukraine or potentially elsewhere. We're also seeing a whole range of responses to the situation in Ukraine. Joint investigative teams, the Commission of Inquiry, the ICC has been engaged. And so we're looking at, again, this sort of decentralized operation of justice around the world. One other interesting innovation that I'd love to see replicated elsewhere is a conflict observatory that a sister bureau of ours has stood up. The idea is to give an independent academic institution, in this case Yale University, some funding to create the tools to gather open source information. The Conflict Observatory is looking at satellite information, some of which actually is behind a paywall, but because they have the funding, they're able to sort of direct those satellites to particular areas in order to inform their understanding of the conflict dynamics on the ground, to scrub social media accounts, and to gather other sort of open sources in journalism, human rights reporting, et cetera, and to put together refined analytical products that then could potentially be used by prosecutors who wouldn't have the time or the technological capability to be able to gather all this information in one place. So the Conflict Observatory now has put together reports on the filtration operations, on attacks on precious cultural property, attacks on educational institutions, attacks on hospitals, grain shipments, all of these various dimensions to the violence and different types of war crimes that ideally will feed into an understanding of what the crime base is, and then free up prosecutors to focus on that critical linkage evidence, connecting what we know to be the commission of international crimes to those responsible individuals. So together, this Atrocity Crimes Advisory Group, which we've now been joined by the United Kingdom and the European Union to sort of fund this effort in Ukraine, is really complementarity in action. It's strengthening the ability of this particular national system to do the work domestically, leaving some of the particular cases, for example, crimes against humanity case or a case involving superior responsibility, to the International Criminal Court, given that there are gaps in the Ukrainian domestic code. We've also tried to do what we can to support national transitional justice efforts around the world, so supporting the Special Jurisdiction for Peace in Colombia. I was in Ethiopia at a really interesting time when the sort of humanitarian pause ceasefire had been in place about 5 months, which had opened up political space for discussions around what transitional justice in Ethiopia might look like. And so I had a whole series of really interesting discussions with government actors, with a series of institutions, the National Dialogue, the Interministerial Task Force, the National Human Rights Commission, about their vision, but also civil society actors that were, in many respects, having to think about this for the first time. There have been a number of transitions there and a number of episodes of violence that have never really been the subject of any sort of a comprehensive response. And so it was a very kind of hopeful time. We then had, of course, resumption of hostilities in the north with respect to Tigray, but now we have a cessation of hostilities agreement that contains within it an explicit promise of pursuing transitional justice. Now, of course, the challenge will be implementation, but at least there's a toehold for that work to be done within the cessation of hostilities agreement. And so that's where things now stand. And so we're looking for ways that the US, working with and through the African Union and other partners, can support that effort and ensure a transparent and inclusive process. I've also taken on as an initiative the imperative of witness protection. Witnesses are, no matter how much exquisite open source information one has, witnesses are still going to be critical to criminal processes, to civil cases, and even to the whole range of transitional justice mechanisms. Their lived stories, their perspectives, their views, their discussion of what happened to them physically is going to be critical to be able to truly understand and to bring any kind of a comprehensive accountability. And yet they're the weak point, they're the soft underbelly of the system. And we have seen a number of cases around the world collapse because witnesses have been literally under assault and have withdrawn, have disappeared, have changed their testimony under threat. And so the international community, in support of the system of international justice, needs to do a better job of thinking about what the best practices are of witness protection and how to capacitate the system so that people can be brought to and helped to get reestablished and resettled in situations if they're not safe in their home country. So we've done a couple of side events at UNGA. We'll be doing a side event at the Assemblies of States Parties next week to try and drum up interest, ideas, et cetera, in order to think about what a stronger and more protective system would look like. So I'll end here now by just looking a little bit at the situation of Libya. And as I mentioned, I'm not a Libya expert, and so I'm really looking forward to our Q&A. Of course, meaningful justice there has been slow moving. I guess that's a charitable way of saying it. Non-existent is maybe more accurate. But there are mechanisms happening and there are efforts happening around documentation. And we know that documentation is the foundation, it's the baseline. There can be very little of any sort of a justice response without accurate information about what has happened. And so that's one area where we try and do consistent funding in order to just ensure that that predicate is available. And then the attention can turn, when the political situation allows it, to thinking about what justice itself might look like. And we continue to believe that resolving the political uncertainty is going to be crucial to have justice play a component in that. We have tried to work on the expansion of the fact-finding mission, which has done really incredible work. I commend their reports to you. They're extremely detailed. It's amazing what they've been able to do without full access around the country, without the resources that they need. Unfortunately, the mandate has only been extended for another 9 months, and so this will be one of the final articulations of the fact-finding mission in order to try and, I hope, pull together some observations. They've put together some very cogent recommendations that if taken on by if not the current government, then a future government following credible elections, would go a long way towards creating space for justice to happen, for victims to bear witness, for individuals to think about what rehabilitation and reconciliation might look like in a particular Libyan context. The FFM, the fact-finding mechanism, has emphasized in all of its reports that whenever it speaks to survivors, to families of victims, they all emphasize the importance of justice, the role that justice must play in any response in a sort of peaceful transition within the country. And that is a consistent messaging that gets heard all around the country. And I think it really lays bare the importance of this work, that when you ask survivors, they have needs, and it includes reparations and livelihood assistance and psychosocial rehabilitation, but they also want that elusive principle of justice. And so that's what we as an international community need to do a better job of providing to individuals. So there's much happening, in conclusion, on the international stage when it comes to international justice, but it really only scratches the surface of the acute needs, and much, much more needs to be done by way of prevention. This was a big initiative of the Obama regime, the Obama administration. We've tried to restart it now under the Biden-Harris administration, but it was in some desuetude in the earlier administration, and there have been so many other planetary crises that have risen to the fore, and so getting it back to the point where it was has been a bit of a challenge, but we are trying to continue to invest in prevention, including upstream when it comes to building resiliency within societies, to building strong civil society actors, accountable institutions, the rule of law writ large, because we know these are essential to help protect against those elements within societies that would want to foment violence or take advantage of ethnic distinctions or historical grievances in order to consolidate their own power and ultimately bring violence to communities. And so just as we know now with the situation in Ukraine, just as the Allies after the Second World War came together to advance the imperative of justice and to create a whole new system of international justice, it now falls to us to continue to foster these principles, the so-called Nuremberg principles, and to ensure that they are strengthened and not just left to the side as we see violence descending in places around the world. But while we focus on the situation in Ukraine, I'm constantly reminding myself that my office is called the Office of Global Criminal Justice. And so we cannot overlook the perception that we hear and see within many states, including within the Global South, that there's the sort of concerted response in Ukraine stands in stark exception to what was a less active and less consensual response to situations around the globe that cried out for justice. And so trying to get that balance right, trying to respect those perceptions of selective justice and bias while still trying to build support for the underlying norms and the principles and the expectations of justice amongst the Global South has been a challenge. And we've seen with many of the resolutions around Ukraine a high number of abstentions. And I think these abstentions don't necessarily reflect a disagreement with the principles within those resolutions, but rather are somewhat of a political statement around visions of selective justice. And why is the world or the global north or Europe so united around this situation when it stood by when violence descended within, say, Central Africa or elsewhere around the world? And so I'm trying to make sure that my office stays focused on these other situation countries, including the situation in Libya, which demands the attention of the world given the high levels of violence there and political uncertainty. So with that, I really look forward to our conversation. Thank you again for including me within this incredible gathering and community, and thank you for your attention.
as I was listening to your sort of whistle-stop tour of what's happening in the world, the student in me was enthralled. And I'm just going, oh my God, there's so much happening. This is amazing. What a great precedent we have here. What an incredible initiative we have there. The activist in me was going, so it all comes down to political will. And so that, to me, is the tension of listening, as a listener to that conversation, because you talk about, is it finding the water, which I really love that kind of metaphor. But it seems to me that when I listen to the narratives, and I know you picked up on this point of the perceived bias by other activists not working on Ukraine, is the question of, when we talked about other situations, it was that justice was a prerequisite to stability. When we talked about Libya, it was stability was a prerequisite to justice. And so I wonder whether we can talk about that tension a little bit and see how we can find those paths to the water in Libya, because I don't see stability coming anytime soon. And I think it's important to really think about what avenues there are in this current environment. And just to kind of situate all this in, the poster for this event and the image we've been using is an important one, because those are the mass graves in Tarhuna. And so as someone who works on this and someone who works with the victims, it's very difficult for us to say, wait for stability, and then the justice mechanisms work. And so I wonder whether we can galvanize some of the thinking, or perhaps we can take some lessons of what we should be doing to encourage better action or create more political will.
Yeah, I mean, it's sort of that age-old dilemma, and I think probably in each context or society, if you're thinking about it as a kind of a weighing of peace efforts versus and stability efforts versus justice efforts, that the balance, the proportions are going to be different, and they may wax and wane over the years. So you can invest and get some outcomes in one, and maybe you sequence responses in the justice side, or vice versa. And that's where I think coming down to this question of documentation is so important, because it lays the groundwork for both. You can pursue that at any time, even in a situation of instability. We've got now the technology and the techniques to be able to do good documentation, even when you can't physically get into the country, because we have Skype, we have the ability to use various technological platforms and others. We have better forensics now than we ever have. But there's no question that getting that balance right is always going to be a challenge. And in some cases, justice just isn't possible because the situation is so unstable. But in other cases, you might be able to make some advances. And that's where I think having this be more of a global and a decentralized system is helpful, because you can have cases being pursued when perpetrators are traveling, or even just opening an investigation or providing an opportunity for survivors who have left the country to be able to bear witness and give testimony in terms of confirming an indictment. So one of the countries I visited was Liberia, where there's been no justice at all domestically, but a dozen cases in courts abroad, because Liberians have traveled, both survivor victims, but also perpetrators. So even in the United States, where we don't have a particularly rigorous international crimes set of authorities, we've been able to use immigration remedies, because individuals lied on their immigration forms when they came into the United States and gained an immigration benefit. So that gives rise to a case for fraud. In order to show fraud, you have to show that they lied, and you have to show that when they said no, they did not participate in the persecution of others, they actually did participate in the persecution of others. So it's sort of an indirect way to put evidence on of what actually happened maybe even 20 years ago in Liberia during their sequential civil wars. So a lot of it is creativity, it's targets of opportunity, it's patience, but also keeping the eyes on the prize and then being ready to act when an opportunity emerges. And we've seen situations turn on a dime. I mean, even in Sudan, which of course has reversed itself, but there was that moment when you had civilian rule again, and it was contemplated that Omar al-Bashir would go to The Hague. That didn't happen. He's still in custody, though, and so that opportunity may happen in the future. But it's being ready to move when the opportunity presents itself, but acknowledging that sometimes it's just not safe, and individuals who are justice actors are not going to be able to pursue justice in their domestic system. And so how can they work with allies and partners elsewhere to try and pursue it elsewhere, or at least lay the groundwork, lay that predicate, so that when the time is ripe, they can move forward when they can.
I won't press this because I'm sure people in the audience will about when the time is right. But I think the other thing that, keeps, as I was listening, we referenced a lot the importance to think of survivors and the importance of empowering survivors. And you obviously also mentioned the role of the ICC in prioritizing that. The ICC brings a lot of questions when we talk about it in the context of Libya, but I think I'll start with two. One is the fact that actually the creativity that you mentioned and the hybrid kind of systems that we've been really trying to galvanize an interest in Libya. Whenever we've tried to make that case, actually the ICC's mandate has been a way to shut us down. Right, you've got an ICC mandate. Why do you need to talk about a specialized mechanism? Why do you really need to have the FFM renewed, the fact-finding mission renewed? Because you have the ICC, it has a full mandate. And so we always go around in circles of saying, is it a blessing or a curse to have this ICC mandate? Because actually you look at situations like Syria, where the ICC mandate wasn't forthcoming, but actually there's a question whether the IIIM and the other mechanisms have been far more effective. And so I guess my question to you is the ICC really worth the support in that instance? But secondly, we've also seen, if we look at this research we've done recently, a big part of Libyans' disillusion with the international system and the international mechanism has been because of the ICC's inaction in Libya, or more recently, the ICC prosecutor's action in Libya, where, less than 24 hours after meeting the families of those in the Tarhuna graves, he had a photo opportunity with the person who's directly or indirectly responsible for that. And so when you have a situation of us saying we prioritize survivors, yet the prosecutor is smiling and taking a photo op with Haftar, who is probably one of the most notorious perpetrators in the country, what message does that really send to survivors? And should we just tell survivors, you know what? It's really not about solidarity with you. It's just about prosecutions. And let's just get over this facade and focus on the prize. Because it is really difficult and disingenuous for us to keep continuing to say that the ICC is a victim-centered or victim-focused court when the prosecutor is prioritizing his photo op with the perpetrator.
I think you're exactly right that, especially in the early days, we assumed that the ICC would do all things for all people, for all situations. And so the wind was taken out of the sails, I think, not just in Libya, but in many other places, Kenya, for example, where there were ideas about implementing the recommendations of the Truth, Justice, and Reconciliation Commission that included a domestic justice response. And everyone said, oh, well, we don't need that anymore because, of course, the ICC will take it. And I think we now realize that it's not the be-all and end-all, but it's part of a system that will have to work more in coordination with efforts happening at a national level. And I hope that everyone's sort of expectations are brought down to a more realistic level here. It was the same thing with the Yugoslavia Tribunal, right? If you read the preamble, it was going to bring about reconciliation. It was going to do this, it was going to do that, it was going to do a definitive historical record. And now we know that what they do best is prosecuting bad guys. That's what they do best. They're not going to be a truth-telling exercise necessarily. They're not necessarily going to bring reparations or psychosocial rehabilitation or even create spaces for reconciliation to happen. If anything, their work may be rejected by certain communities that would make it harder to have reconciliation. We've seen this, I think, in the former Yugoslavia communities. And so, focusing on what the ICC can do and what it does well, but then looking for opportunities to build other institutions domestically. And the question of timing, I think, ultimately is for each individual society to decide. Obviously, working with donor states, with partners, with this epistemic community of international justice experts. But that's for the particular societies to decide, and the hope that they can find allies that will help support them when they decide that this is an institution that's worth investing in, or we want to think about how to design this institution. So in the Gambia, for example, they're conceptualizing also a hybrid court, but with ECOSOC, ECOWAS, which is the sub-regional organization there. What would that look like? Who knows? It's never been done before, but let's work together to bring communities that have had hybrid tribunals to talk about what worked, what didn't work, where things went wrong, how to fix them, how to think about tailoring it to a particular society. And so creating, I think, spaces for communities to talk together and to figure out what's going to be the best model for them. And then hopefully the donor community and others can support those decisions when they're ready to move forward.
Sorry, I'm just trying to process this, because it all then comes down again to that point of creating political will, because it's easy enough to say it's about the communities that want them, but actually, is it? Because, you know, in Libya, the international actors are so present in every decision at the micro level, at the almost daily level of what happens in Libya, to then absolve them of responsibility when it comes to the point of accountability, I think is problematic. And, you know, we've been looking about frankly, the legacy of the international intervention in Libya. And I would, you know, actually we say that we think the biggest legacy is enshrining impunity. Because, you know, not only are we seeing lack of political will, but actually active impediments to justice. So simple things like the non-renewal of the fact-finding mission. There is no rational reason why that should happen when the atrocities have not stopped. You get, you know, the ICC's budget not being really properly allocated for Libya. It's under-resourced. You get the situation where you have perpetrators in Europe being granted special mission immunity regularly. So even avenues of universal jurisdiction are blocked to us. So we might have the most beautiful dossier on someone, but if they go to France for medical treatment and they're given immunity by the French authorities, we can't do anything about that. And so I think it's important to, when we talk about accountability, to not just look at the accountability of the perpetrators, but also on the accountability of those protecting them. And so I would really want to get your thoughts on how we push back on this, because I think that's really where that culture of impunity is not internal, it's external as well. And that's the pivot that we need to do this work.
No, I hear you, and I don't want to say that it's not about political will. There are certain conflicts, certain situations that sort of capture the imagination, I think, of powerful actors within the international community. And that may be at an emotional level, but it may also be because that's a narrative that fits with the other priorities vis-a-vis that particular situation. And there are times when accountability is not considered a priority, where they've prioritized, as we got to the first question, issues of stability or counterterrorism or whatever it would happen to be. And that's where the investments are happening. And so, you know, I have a tiny office, and so I'm constantly pushing the justice narrative and the justice agenda, but I get overruled. And that's how governments work, right? There are multipolar, and there are many different, we're always balancing a number of different agenda items. But having a consistent voice, I think, keeps at least the issue alive. And that's partly what I think offices like mine try and do, what activists try and do. But I think finding ways to work together to put forward concrete proposals and then present those in fora and then have the fora reject those or resist those, I think can be a helpful way to force these issues up to the surface. So at least it gets acknowledged, and at least parties that have the power to do so have to say, this is not our priority right now, this is not where we're going to be investing. But then the idea is still there, and you can continue to push for it. And then, again, if the opening happens, then it's ready, and you're ready to move forward. So I know it's not a satisfying answer, but that's but we're admiring an exquisite problem. Yeah. And I think we agree with what the problem is. And so the question is how you overcome.
And I think we've been told for the best part of a decade that we should always be failing forward in Libya, right? But at some point we need to be succeeding forward as well. And so I think I'll pause there, and I'll open it up to the floor. And let's start this ball rolling. So I've got one here, one there. Go ahead.
Okay. Thanks, Ambassador. I have two very quick questions, because I know many people have questions here. You rightly say that impunity has been rife. Elham knows that in Libya in the last 10 years or even longer, and especially looking at the macabre image behind you there. And I totally agree with that. There is actually one area where Libya's prosecutors have done sterling work, which is in prosecuting ISIS criminals. Now, in the very limited work I've done with them, but a lot of relationships I have with them. The complaint they've raised with me, I can't verify it either way, is that the superpowers, and they mean Europe and the United States, have provided very little assistance in tracking down, investigating and prosecuting these criminals. Now, just to put in context, those who have investigated these people are young men and women in Libya who are on minimum salary and working hard, often at grave risk to themselves. Can you confirm or deny what the United States has done to help the Prosecutor General in bringing to justice hundreds of ISIS criminals? The second question, which is less important, but I might as well ask it. You say that one of your mandates is to advise the Secretary of State. Do you have any relationship with the Department of Justice in relation to alleged war crimes of US nationals abroad? And one mentioned by Elham is an ideal example. Do you have that relationship? Thank you. Oh, by the name.
Well, you should introduce yourself.
Oh, sorry. As it's been recorded, I was going to not introduce.
Oh, sorry, you don't have to.
No, that's all right. Sorry. Mohammed Shaban. I'm a lawyer. I generally represent Libya in international arbitration, which is civil in matter, commercial in matter. But with the ISIS case from 2014 to about 2020, I've assisted. Not much, but I've assisted. What does come out a lot in their complaints to me, as if I'm an ambassador, I'm only a lawyer, is that why don't the British help? Why don't the Italians help? We are prosecuting criminals for them. Most of them actually, or a sizable portion of them, are not even Libyan nationals who are behind bars.
Thank you, Ambassador. Ibrahim Alabi, as I'm a barrister at Guernica 37. Having been working on Syria for the last 10 years, being there when the chemical attack of Khan Sheikhoun took place in Idlib and so on, I stopped explaining what I'm doing or convincing myself that it's justice, and I started using verbs like fighting impunity and working towards something, because I don't believe with kind of mass atrocities that you can achieve justice. But when I'm engaging with civil servants who stay in a post for 2 or 3 years, they seem to be outcome-oriented. Like, oh, why should I start this process if it's going to take 15 years to catch X or so on? So how do you kind of, the incentive structure, the kind of career incentive structure within an office like yours must be very interesting to kind of continue this, by the end of your mandate to say what you've achieved. Is it also kind of process-oriented or is it outcome-oriented? And my second question is, having worked on Syria for so long, when Ukraine started, I was amongst the minority that was actually kind of excited to be able to do something on the kind of Russian aggression into Ukraine and the crimes, partly because it's a just cause, but partly because I saw where there is political will. Do you see that as an opportunity to cement precedents? Like what's happening now, that then we can use for other conflicts to kind of have something to say, well, you've done that here, why you're not doing it there, rather than saying, okay, I'm not going to get involved for kind of whataboutism reasons.
We've got a question, our third question there. Yeah, go ahead. Can we try to limit it to one question? I don't want to set a precedent of 2 questions per person.
Okay, one question. I'm Kate Cronin-Furman. I'm an associate professor of human rights down the road at UCL. Hey, Beth. So I think, we can all point to a couple of really obvious things that differentiate Ukraine from some of our other cases of mass atrocities and the pursuit of justice. But I wondered if you could talk about the implications of the fact that these are atrocities committed by one state on another state's territory, and the fact that that is quite different to most of our other cases. How much does that matter for the challenges and opportunities of pursuing justice? And related to the previous speaker's remarks, when we think about the implications for the norms going forward, is it a comparable case or is it going to end up being a one-off?
And just so to say, I forgot to mention at the beginning, we're streaming this in Arabic to our Libyan audience, and so can I ask that any questions we have from that audience be shared in the next round?
Yeah, and I forgot all about that, and I talked really quickly. So apologies to the interpreter. Okay, so I think I got them all. The ISIL question. We have no embassy in Libya. So it's really hard for us to do much, honestly, in terms of this kind of support there. We have, individuals who are focused on Libya, but we don't have the kind of base where that normally would be doing that kind of support to either civil society or to national authorities. I originally thought your question was going in a slightly different direction, which is, why do you see, as we do in Syria and other places, such a high degree of investment in some of the foreign terrorist fighter cases, the ISIL cases, cases that have a counterterrorism kind of valence to them, versus more of the atrocity crimes cases. And there's been a push recently to be thinking about concurrent charging, and so not relying solely on terrorism charges, but thinking about how to add atrocity charges into indictments. For example, war crimes or even crimes against humanity, if the domestic code will support that. And we've had issues in the United States. We have the Samantha El-Hassani case where she gets charged with material support for terrorism because she was conveying money and materiel and such into ISIS-controlled territory with her now dead husband. But she also, with her husband, bought Yazidis, children. Now, by many accounts, she loved them and treated them like children and tried to protect them against her husband, who was violent towards them. But she committed the crime of slavery and potentially the crime of genocide and other acts. And yet our Department of Justice only charged the counterterrorism type charges. Now, why do they do this? Well, many reasons, right? A, sometimes it's just wanting to get an easy outcome, and that's a much easier crime to prove. We don't have a lot of precedent charging slavery crimes in the United States. And so, that would be breaking new ground. It would be having to prove a whole set of elements that have never been proven before. How do you prove that with evidence if the 3 children will recount that she loved them and that she cared for them even though she'd bought them earlier? And then, of course, genocide we know is very difficult to prove. And so I understand the resource constraints that go into pushing prosecutors not to pursue what we would think about maybe as symbolic or important precedents to establish precedent in the law, and to rely instead on an easier set of charges. In Europe, I did a little bit of an empirical survey of the cases that have been brought, and there's actually been very active cases in the Syria conflict. It's one of the few glimmers of justice we've had with respect to that conflict. And, they're very opportunistic, and they trended early on cases against ISIL members, foreign terrorist fighters, et cetera. But then that did start to shift, and we saw some regime figures actually face justice finally, and under more war crimes or so-called atrocity crimes charges. And so when you're dealing with extraterritorial cases, these are often episodic and opportunistic. It's who falls within the jurisdictional reach of a particular national authority and what legal authorities do they have. So Sweden doesn't have a material support for terrorism law in the way that we do, so they would have to think more creatively about trying to use what international crimes statutes they have. You asked about the relationship with the DOJ. So there is a Human Rights and Special Prosecutions Unit that sort of has jurisdiction over our international crimes statutes. We have a war crime statute, but it only allows for jurisdiction if the perpetrator or the victim is a U.S. person. So it will not be particularly useful for Russian war crimes against Ukrainians, but there are U.S. persons in the battle space, and so I know that they are looking at those cases. Are they looking at other individuals you may have in mind? I don't have any insights into that. I'm a foreign policy office within the State Department. I'm not a law enforcement office. And so while we work together with them quite a bit, and we often provide diplomatic support for their work, we've done work on the Hill when we're thinking about trying to reform, including our war crime statute, which the Ukraine situation has inspired a lot of work on that statute, recognizing that it's essentially been a dead letter, it's never been used, and here's an opportunity to apply it to a situation that only with amendments would it be at all applicable. But I don't have any insights into their investigations. They hold that very close to their chest. Syria, Ibrahim's question. I can't even read my own handwriting here. So one thing that we've seen, which is a new pattern and is actually, I think, quite exciting, is these public-private partnerships that are happening where these cases are hard. They ask normal domestic prosecutors to understand a whole set of crimes and elements that they've never used before, to gather battlefield evidence, to deal with traumatized victims who don't speak the language, who aren't even familiar with maybe a legal system or are familiar with a very different legal system than the legal system that might be proceeding with respect to or considering a set of charges against someone. They're really hard, and there's a lot of barriers to moving forward. And so you can imagine a prosecutor that isn't maybe mission-driven, thinking, it's not worth it. I don't have the resources. I don't have the people. I don't have the time to pursue this. And so what can we do to overcome some of those barriers, to move them towards a process where they say, okay, I can do this, I can manage this. And civil society has stepped into that breach and has started to do a lot of incredibly important work in terms of understanding the crime base, understanding the system, even creating dossiers on responsible individuals, helping to identify witnesses who are willing and able to testify, accompanying those witnesses to help them experience the system of justice, explain to them the various stages. What does it mean? Where are we in the process? When you see the perpetrator there, does that mean they've been let off? No, they're just not in pretrial detention, or they are in pretrial. Just understanding the whole system, and then helping to avoid the kind of re-traumatization that happens by ensuring that they have support persons and whatever support they need. And so civil society has really stepped in to essentially do what had been previously reserved to sovereign actors, investigating crimes, identifying perpetrators, putting cases together, and then the next step, of course, is the bringing of charges, which civil society can't do, but in some systems they can initiate at least a criminal process, and we're seeing civil society actors do that. So that I see as a sort of a bright spot. Now, we do know that in some European systems, the ability of survivors to initiate cases has been curtailed in a kind of backlash against universal jurisdiction, but it still exists in other places. And even in the United States, we have strengthened our victims' laws to give kind of some participatory rights to survivors in a criminal process. And advocates are increasingly understanding what that entails and trying to use it on behalf of their clients. So the precedent question, I actually do think that a rising tide is going to lift all boats. I see the criticism or the concern that all the attention is going to Ukraine, and we're seeing this incredible solidarity and consensus and coordination amongst the European prosecutorial groups under the Eurojust network through the joint investigative team. But it also, I think, is building a kind of a muscle memory around this work that then will make it easier to pursue other cases that might be of and involving and coming from societies that are not, European societies, where you have that kind of it feels like an easier case to understand. It's a very clear, act of aggression by one state against another. It's not a complicated civil war where you've got a fractured opposition and you've got a transnational terrorist organization involved, and all of the challenges that come with prosecuting cases under messy or quote unquote conflicts. This is as Kate was saying, it's a little bit of an easier model to sort of wrap your head around. It's sort of World War II era kind of stuff. We understand that. We recognize that there's a good guy and there's a bad guy, and those are easy to identify. And when you have a situation like Syria where it just devolved into a big mess, you can imagine prosecutors saying, I don't even know how to classify this conflict. I mean, our war crime statutes requires prosecutors to classify the conflict. And if they get it wrong, or if there's a defense that says, well, no, it actually is an international armed conflict, that's an element that has to be proven. And so it's a barrier to a case moving forward. And so I do think, though, that building that muscle memory, getting prosecutors more comfortable, getting them used to working together, getting them used to working with civil society, getting them used to sharing information, reducing some of the friction around mutual legal assistance. I think that will benefit all situations, particularly in the extraterritorial realm. I'm also hopeful that the kind of project that my office is funding will be a model that we can then apply elsewhere in terms of that capacity building approach, that mentoring approach, bringing experts that have done similar cases, even if in different contexts, to work side by side with their counterparts to say, this is how we do it, take it or leave it, here's what my learning, maybe this will help, try this, and then build that capacity domestically so that those cases can be brought. And then finally, I think I answered the last one. Yeah, good.
Just as we collect get to the mics, there's one there. I also wanted to, I'm going to come to you in 1 second, but I wanted to pick up on the question that you mentioned, this model of civil society supporting prosecutions. that obviously raises the concern of the protection of the civil society actors, which in at least some of the instances we've worked on has not been as comprehensive as we would like and we would expect to see. So it'd be great if you could pick that up. So I've got Roland.
Yeah, Roland, and I'm actually looking forward to hearing your daughter's question. My name is Roland Paris. I'm a professor and director of the Graduate School of Public and International Affairs at the University of Ottawa in Canada. First of all, thank you for the work that you're doing, Ambassador. I was wondering if you could share some thoughts about the different possible models for a Ukraine tribunal. And specifically, is this the kind of thing the General Assembly could approve, since Russia would obviously veto anything in the Security Council? Would the idea be to try Russians in absentia? And what's the U.S. government's current position on any of these things? Thank you.
Yeah, go ahead.
Oh, thank you very much. Thank you very much, Madam Ambassador. So nice to see you here. My name is Michael Russo. I'm a master's candidate just down the road at the London School of Economics studying international development and humanitarian emergencies. I saw a couple weeks ago that you were in Buenos Aires meeting with Argentinian prosecutors working on cases of ongoing crimes using universal jurisdiction. Could you give us a sense of the prospects that you see for prosecutors working in situations where domestic judiciaries are so compromised, but where those states aren't states parties to the ICC, like the situations in Burma or Nicaragua? Thanks very much.
Great. Terrific questions. So yeah, obviously the role of civil society can put people in extreme danger. There's no question about it. And some organizations have a greater risk tolerance for this work than others. Some individuals have a greater risk tolerance for this work than others. And my understanding of what a lot of organizations that do this work, the approach they take is that many people who are drawn to this work or who want to do documentation work, it's a calling for them. They're going to do it one way or the other. And so the best thing to do is to make sure that they have the tools and the training to do it as safely as possible, so they have contingency plans in place, so that they have technology that enables them to, wipe their phone if necessary, et cetera, panic button, whatever it is. So that if they're going to put themselves at risk, it's not in vain, and that you can ideally collect the information to such a degree that it can actually be useful for future processes. And so I think that's something that every organization has to decide. I have, in my past, directed a human rights law firm, essentially. I was the acting director of the Center for Justice and Accountability, and we often had this question of, what were we comfortable doing in terms of working in the field, particularly in terms of putting our names out there versus working more quietly. And that's a decision I think every individual and then ultimately every organization has to make. But your point is a good one, that if law enforcement elements are reliant upon or working with these organizations, they have to respect and acknowledge the risk that these entities are taking, that's essentially doing the jobs that you would think that ordinarily investigators might be doing. That may make sense because they may be able to operate in societies more undercover than a foreign investigator might be able to do, but they also don't have the benefit of carrying that foreign passport. And so, getting that balance right is something that should be, I think, discussed in a very honest and open way. And prosecutors need to understand the types of risks that many of these activists are taking when they're out there trying to collect information. The aggression tribunal is a really interesting question. I mean, there's no debate, I think, that Russia has committed a manifest violation of the UN Charter in its original invasion of Ukraine and now its full-scale invasion of Ukraine in February. And the crime of aggression has never been prosecuted since the World War II period. And indeed, the Nuremberg Tribunal was meant to be the trial, was meant to hold the trials to end all war. Unfortunately, that prophecy or that aspiration did not prove to be sort of prophetic, and we've had many wars since, but no prosecutions. And so this idea has been revived, and it's something that President Zelensky cares very deeply about and has been advocating for in his bilateral relationships and multilateral fora, and most recently has gone to the General Assembly with a zero draft that would acknowledge or imagine some type of a tribunal. There are a couple of different modalities that are being explored by European entities, by Ukraine itself. One is, as you describe, a General Assembly type organization, because of course the Security Council would be blocked. That was the way in which the original ad hoc tribunals were created, was through a Chapter 7 resolution by the Security Council, where Russia enjoys a veto, and so of course would veto any effort and has done so, and including in places like Syria, where any resolutions with any consequential issues have been vetoed, or Russia has used its pocket veto to prevent those from moving forward. The idea would be that a bilateral treaty would be drafted between Ukraine and the United Nations, blessed in some respect by the General Assembly, bringing the political support of the entire international community. And then it would be a standalone tribunal that could prosecute. The vision is just the crime of aggression, which is a leadership crime. So it would be a limited number, probably, of defendants, probably the top political leadership and maybe some top military actors as well. There's some precedent for this. So the Special Court for Sierra Leone was essentially created in this manner, although did have some involvement by the Security Council. But it's out there. Now, in that case, you had the consent of the territorial and the nationality state. In this case, you would not have that. You would have the consent of the territorial state, but not the consent of the presumed and ultimate nationality state, which of course would be Russia. So it would break new ground there. A second modality that's been considered would be a regionally based, either an international or a domestic court with hybrid elements. And so rather than an arrangement with the General Assembly, it would be an arrangement with the European Union or maybe the Council of Europe. Again, in a kind of a bilateral treaty with Ukraine adding the domestic element, and then the EU or the Council of Europe adding the international element. Theoretically, that entity, whatever it was, could be blessed by the General Assembly. It could also be opened up to participation by other states. The Tokyo Tribunal is an interesting model where Nuremberg was really the 4 victorious allies. Tokyo, however, was much more involvement of some of the allies of the 4 allies, and so it had more international elements. And of course, you have the famous dissent of the Indian judge that brought in some new ideas that would not have been articulated had it just been the 4 original allies. So those are the models that are being pursued. Conversations are literally happening as we speak. But this is something Ukraine wants, and I think that's going to carry a lot of weight. The question is, will they have the votes at the General Assembly? So far, all of the resolutions have prevailed. The numbers have been quite strong. The numbers on the Claims Commission resolution have been a little softer, but there's still a very strong majority there. And so it may be that Ukraine feels like they can get that majority and have the blessings of the General Assembly. We have not taken a firm position on this. We're looking at all the angles, certainly supportive of taking some interim steps, particularly when it comes to preserving evidence. One thing I've been quite proud of is how quickly the United States has been able to declassify information. This is often a battle, but they've been able to declassify information in order to shed light on Russia's planning, advanced planning, and also what's been happening on the ground, when normally we would not have been willing or able to reveal that information. And so that might be another way that we could contribute to a better understanding of the steps that were taken and the individuals most responsible for this terrible war. When it comes to, my trip to Buenos Aires was really fascinating. I was invited down there to give a talk at the Parliamentarians for Global Action, which I was able to give an intervention. It was very much focused on the ICC and the U.S. relationship, and I was happy to be able to revive a sort of a talking point that had been part of our messaging, but had somehow sort of gotten lost, and that was that we have no objection to other states joining the court. That's a sovereign decision. We're not there, and it would take, I think, a lot of political transformation within Congress to get to a point, but we can still be supportive of the Rome Statute system in multiple different ways, as I've sort of outlined. But I also met with prosecutors in Buenos Aires who are bringing 2 sets of cases. The first set of cases is a whole bunch of historical, by a whole bunch, I mean hundreds of historical, I don't know if dirty war is the right term to be used anymore, but historical cases arising out of their dictatorship era. Those cases are still being brought today, even though they were from the late 70s, early 80s. We have 90-year-olds that are finally facing justice. And there's an incredible memorial at one of the clandestine torture centers where the tour ends in a room in which the photographs of individuals who have been successfully prosecuted are flashed on a screen in front of you. It's remarkable what they've been able to do as part of a transitional justice process that is not a 1 year or 2 year exercise. It's a multi-generational exercise, and they're still engaged in it. But there's a second set of cases that was really interesting to learn more about, and this is their universal jurisdiction cases. They have a very expansive law. It allows them to initiate a structural investigation into potential international crimes committed abroad and get very far down the way in that investigation, even to the point of inviting witnesses, victims, survivors to come and testify in open court or closed court, as the case may be. And there's talk of potential Rohingya victims coming from Cox's Bazar to come and give testimony. A victims organization has initiated a criminal complaint against members of the Tatmadaw, the military junta in Myanmar. And so that case is moving forward. There's a Nicaragua case. There's even a Franco-era case from Spain, and other cases looking at other atrocity situations around the world. And so, what are the prospects of a Burmese general traveling to Argentina? Not that high, but if they issue a summons and that gets rejected, they can then issue an arrest warrant, which can then go to Interpol, which can then result in the creation of a red notice, which then means that it's more difficult for that person to travel literally anywhere. Now, maybe they're never going to travel. They're never going to leave that place. But if there's a political transformation, maybe they have to leave, in which case, then they're fair game and indictments are at the ready. And this is the same with respect to Russian perpetrators. When we talk about what are the prospects, if there's no political transformation within Russia and those individuals remain within Russia, it will be very difficult to bring charges against them. There is the possibility of in absentia cases. Some systems allow that, as Ukraine's does. Many civil law systems do. The European Court of Human Rights has set forth a series of standards to evaluate when they're fair from a due process perspective, but there's nothing inherently wrong with in absentia proceedings so long as they meet those due process standards. Are they as satisfying to survivors? Are they as satisfying to observers of justice? Probably not, but they do provide a forum for victims to testify. They do provide an opportunity to pull together evidence, to create a historical record, et cetera. And then if those individuals do fall within custody, they're entitled often to a retrial, which then can start a justice process that's truly adversarial. And they can put on defenses and have to answer the charges directly against them. So I see the merits in initiating cases, even though you're not sure you're ever going to get a custody over a defendant, or potentially exploring a fair system of in absentia trials. There's not great experience within international justice. The one we have, besides the Nuremberg era, where there was at least one case, the Special Tribunal for Lebanon ended up being purely in absentia trials. I think people realized that was not a great outcome necessarily. And so, that will be, historians will continue to evaluate whether that exercise was worth the effort. But I do see some benefits in what Argentina is doing. And I will tell you that Rohingya around the world all know about that case. They have detailed understanding of what Argentine law allows. And so it does, I think, articulate a type of a solidarity and brings a sense of hope to people to realize that some faraway court in an entirely different continent is actually trying to understand what's happening in Burma.
Can we pause that just for a little bit of suspense and see if we have questions from Libya?
Yeah, so I'm going to communicate. We have 2 questions.
Okay, great. And then I'll get to your question.
No, yours is the finale.
Okay. Save the best for last.
So we have 2 questions from our audience in Libya. One of them is, how do we put an end to corruption, which is rampant in Libya, from police stations to courts and higher institutions? How can countering corruption relate to criminal justice? And the second question is, how can the Libyan people trust US actors in Libya when there is so much well-founded skepticism towards Western intervention?
Yeah, so I think we need to do more thinking about the interplay between corruption and atrocities. I think that's an under-theorized area. I think we see corrupt actors benefiting from the perpetration of atrocities, and they use atrocity situations in order to further corruption. And so we need to untangle that. I think the U.S. Global Magnitsky Sanctions Authority, is starting to get at that interface between those two, so we can sanction individuals for corruption, but also for human rights violations under Global Magnitsky, and I think that's reflecting the fact that these phenomena are interlinked, and so getting at one often helps get at the other, and sometimes it's kind of an Al Capone situation. That reference may not be understood to others, but you prosecute someone for whatever you can get them on, and sometimes corruption charges may be easier than atrocity charges. And one interesting phenomenon that I've seen in a number of different situations is you have a particular narrative that someone is a war hero. That, let's take Augusto Pinochet in Chile. He saved Chile from terrorists, right? He, defended the republic. Yes, okay, maybe he took some excesses, but his intentions were good. And so there's resistance to prosecuting him for the commission of crimes against humanity. Then it gets discovered that he was also lining his own pocket, right? He was engaging in corruption, in self-dealing. And suddenly that kind of support, that narrative of the war hero starts to erode, and people become more willing to think about prosecuting someone not only for the grand corruption, but also for the acts of violence that they were responsible for. And so I think exposing the links and the fact that sometimes these are the same bad actors, I think can help create more incentives and momentum around justice. And obviously the trust deficit is enormous. And, I don't know what to say to that other than, develop those relationships and make sure you're conveying the truth of past practices and what sort of knock-on effects they have had and what should have been done, so that in the future, to the extent that there are partnerships or efforts to assist with these measures, that they will be more responsive to local priorities, needs, expectations, et cetera, and not sort of imposed from the outside. So should I answer the... Yeah.
Thank you very much, Ambassador. I just wanted to ask about, so you talked a lot about ending impunity and how this is important and it allows the water or justice to seep in. And I wanted to ask, to what extent are we also ready to investigate other actions, like, let's suppose, NATO's actions in countries like Libya to actually crack this impunity situation that we have? And one last question, just a very short one. You've also talked about looking at the ICC as a part of an ecosystem of justice and how it's a tool to maintain peace and, or at least to push further to push justice further. And what does it take to make the bridge closer to get ratification from the US to the Rome Statute? Thank you.
Yeah, I mean, both really good questions. I think obviously the doctrinal answer is that these rules, these prohibitions, these norms are jus cogens, they apply to all actors, and then they should be enforced against all actors. But I think the reality is, and it's been implicit in many of the questions here, is sometimes there's more political will and more consensus around enforcing these norms and expectations in certain situations and not others. But as we slowly build a set of precedents, I think we're moving into a situation where that selective justice will start to erode. And all parties will be equally responsible for ensuring that their conduct and the conduct of their actors and agents is consistent with international law, or risk accountability in a foreign court, or pressure to do that work domestically, which is ultimately where we would like to see this happening. And I think one knock-on effect of the movement towards universality around the International Criminal Court is that states are increasingly incorporating the prohibitions against international crimes into their domestic codes, like we've seen in Argentina and elsewhere, so that they can bring these cases in their domestic courts. And so we have now a much stronger system and more consistent system around the world. And I know that Trial International is about to release a huge study where they've looked at the criminal codes, the penal codes of the world, and are tracking the implementation of these prohibitions, and also the ability to exercise various forms of extraterritorial jurisdiction, including universal jurisdiction. It's very difficult to ratify treaties in the United States. We are on the outside of many multilateral treaties that the rest of the world have ratified. So the Convention on the Rights of the Child, we're the only state that has not ratified that. The Law of the Sea Treaty, which would benefit us in the Arctic, for example. We have not yet ratified that. We have a very high threshold. It took 40 years to ratify the Genocide Convention. And so this is about our Senate getting to the point where they're comfortable joining an international institution that could potentially hold U.S. persons responsible. But as we know, the way in which the ICC has been designed is that contingency already exists, because it's sufficient that the territorial state has ratified the statute. Now, we have a longstanding objection to the ICC exercising jurisdiction in those situations, but that's what the statute says. And the court has already moved against certain individuals who hold a nationality of a non-party state. And so it's not clear that that longstanding objection has any currency before the court. I think it's going to be a matter of time before we ratify this. But what I'm trying to do with my role, and what I know Ambassador Rapp has tried to do, is to say there's still lots of ways that we can support the system. And if you imagine a sort of grid where you have ratify, yes, no, support, yes, no. You want us to be in the yes, yes square. Nobody wants us to be in the no, no square. Would you rather us be in the yes, we've ratified, but we don't do anything, versus the no, we haven't ratified, but we're trying to do as much as we can? And so that's the square that I'm operating in now, is trying to figure out how much I can be supportive, even as a non-ratifying party.
My daughter started reading her book. She's given up on that.
Okay. So I love my job. It's incredibly confounding. It's exhausting. I meet often with survivors. These are incredibly intense interactions, and I feel impotent in the face of that, even though I'm working with an enormous machinery that, if we could get the machinery to work in a particular direction, it can do incredible things. If I look back on my life, all of the various threads have moved in this direction. And so I hope that all of you, the students here and you especially, will find a job that you're passionate about, that you wake up every morning and you think to yourself, what can I do today to advance my mandate? And that when you leave your job at the end of the day, you say to yourself, thank God I was there, because if I wasn't, something wouldn't have gotten said or something wouldn't have gotten done. And so that's a meaningful life, I think. It's incredibly hard work. And so for anyone in this field, I really encourage you to ensure you understand how vicarious trauma works, the importance of self-care, of having a physical practice, of surrounding yourself with supportive people, especially whoever your life partner is, because this work is hard, it's exhausting, it takes a personal toll. But it's also invigorating, and I find that I am inspired every day when I work with survivor communities to see the kind of energy and hope that they bring to their work, that they never give up in their own communities, their own societies, and the international community that just lets them down on a regular basis. And so while I have a week or a day where I'm doing nothing but fighting a bureaucracy and engaging in interagency negotiations, where I'm just trying to get an A to a the, or a the to an A, and that is a triumph for me. That's a lot, but then I go out into the field and my batteries are just completely recharged, and I can go back and fight the fight again. So for the young people out there, find a career that gives you that kind of energy and makes you feel like you're making an impact every day.
Thank you so much. I don't want to take any more of your time because I'm impressed we've ended up on such an uplifting note. So thank you. And we'll go listen to Farah now, whose name means happiness in Arabic. And so I think we all need a bit of that. I want to take a quick round of thank yous. Thank you so much to Lutz, to the Human Rights Law Center, to SOAS for hosting us in various permutations as LFJL. I want to thank Libya and the UK, which is a wonderful organization of Libyan youth here that's about changing the image of Libya in the UK, who've supported us in promoting this event. I want to thank the Dutch Ministry of Foreign Affairs for sponsoring this and for sponsoring a lot of our work around accountability. We are absolutely indebted to their vision and long-term support of us. And I absolutely want to thank every single person in the LFJL team. I get to sit here and get the spotlight, but I do very little compared to the phenomenal team that's everywhere today making this happen. Everyone has been wonderful, but I especially want to thank Christina, Ali, Marina, Shun, and Lena for just really pulling this together. I think you will agree that they've done a good job. If you want to support us, please speak to us and we'll tell you all the many ways you can. And they don't all rely on your pocket, although we don't mind that. But you can also volunteer. And if you want to look at a career in this field, we offer lots of intern opportunities. So we always like to say that at places like this, because we love SOAS students. So please do get in touch. And with that, thank you. And let's go listen to some music and have some canapes.